Hello and welcome to the Rogers Brief for April 20th, 2024. I'm Adam Rogers. Thank you for watching and thank you for listening. We're going to be talking this week. I'm going to be talking this week about the fourth anniversary of the tragic shootings in Portapique and central Nova Scotia and some of the fallout this week. The Justice Minister in Nova Scotia resigned from his position last night after some comments that he made about the anniversary, dealing with some of the implementation and the recommendations from the Mass Casualty Commission and some of the blowback of those comments from different gender-based violence groups around Nova Scotia, women's shelters and such. Opposition politicians very critical of the Justice Minister, and last night Brad Johns tendered his resignation, so I'm going to talk about that a little bit in a moment. Also, the Zameer case. People who if you've been listening in the last few weeks on the Sunday night show with Paul Palango and Jordan Bonaparte and myself, we've been talking about this case out of Toronto with this guy Zameer, an accountant, 36-year-old accountant, him and his wife in a parking garage. Zameer ran over a Toronto police officer in plain clothes and is now before a jury. Well, the judge has been very critical of the Crown prosecutor and the prosecution of the case, and so has given some instructions to the jury. I'm going to go through that. Speaking of juries, the big jury selection in New York City this week in the Donald Trump, Stormy Daniels trial. We'll talk about that a little bit and some of the considerations that are in place there that certainly would not be the case in a regular jury trial or certainly a jury trial in a Canadian court. This week also saw the introduction of the federal budget. I talked about that a little bit in a video that I released a couple of days ago, just generally speaking about the spending, the high level of spending, inflationary levels of spending that the government is planning over the next few years. And today I'm going to talk a little bit more about what's in the budget in terms of justice issues. And so there are some discussion about justice-related programs and funding for judges. An interesting little dig at the province of Alberta in the sort of buried in that section. Then a couple of cases out of Nova Scotia I thought were kind of interesting. One because, well, not only because of the application itself, but the person involved, which is Jeremy MacKenzie, who's come to some fame in and around the pandemic and his reactions to it. Well, he's under some charges: mischief, criminal harassment, harassment through telecommunication, and intimidation, and is making an application to have those charges withdrawn or dropped because he alleges that his right to counsel was violated. Finally, the last thing I'm going to talk about is a decision this week out of Nova Scotia courts dealing with video testimony. And this decision from Justice Duffy represents, I'd say, a change, a significant change in how courts will potentially, if it's adopted by superior courts and throughout Nova Scotia, change in the way that remote testimony is heard or determined whether it's appropriate for a witness to testify by video. All right, before that, just a couple of very quick things I noticed in the news. I always kind of scan the national news to see if there's other stories out there that are worth picking up on. There's a couple of quick things. One, a case out of BC Family Law Act. There's amendments in there where pets are now to be considered. And so we have our first split custody decision on a pet. And it is a golden retriever named Stella, looking very nice in the CTV article. Stella is going to be split 50-50 between the two separating individuals. Her caregivers, owners, companions, however people want to talk about dog and human connections. So one of the couple had bought the dog, but immediately then signed a paper saying that it was shared jointly. So that was the way the court determined it. But the Family Law Act of BC says that that's how courts are to consider pets in the determination of, along with property and other things. The other one was a pandemic sort of related case out of Saskatchewan, and the guy's name is Michael Gordon Jackson, they say in the article. Again, this was a CTV article. A father who had separated, the couple had separated. He didn't want his daughter to get the vaccine, even though in the custody order it was for the mother to make those health-related decisions in consultation with the father. So she had consulted. He sent her a whole bunch of articles about the vaccine and how terrible it was. And when she didn't agree, he took the daughter and went to BC and was gone and incommunicado for some time. So strangely, in my view anyway, this was a 2-week jury trial to determine whether this man broke the custody order. The jury took about 2.5 hours to decide, and a short jury deliberation like that usually means they had enough time to get lunch and then took a few minutes to decide the case. So he was pretty clear that that was the reason. He says this was a justifiable reason to breach the order. The jury says no, and that was how that was decided. So just a couple of cases that kind of jumped out at me from other jurisdictions. All right, so let's get into the main stories for this week. First one. The 4th anniversary of the tragic shootings in Nova Scotia from 2020, April 18th and 19th, and that was commemorated this week across Nova Scotia. Moments of silence encouraged by the province at noon on both days. And we'll be talking more about this, of course, tomorrow night on the Sunday Night Show, live at 9:15 p.m. on YouTube on the Nighttime Podcast Network. So the big news, though, this week in Nova Scotia were the comments from the Justice Minister, former Justice Minister now, Brad Johns. He was asked whether domestic violence was an epidemic in Nova Scotia, and he said no, it's not. And it is that there's lots of other problems, violence, drugs and such, and domestic violence, gender-based violence was just sort of in the mix. Well, that got a very strong reaction from not only opposition politicians, but the Antigonish Women's Resource Center, and some other organizations, trying to confront gender-based violence. Now, nobody was really too keen on getting into the etymology of what epidemic actually means, but that wasn't really the point. They were insensitive comments. Immediately, the Premier distanced himself from the comments. The Justice Minister himself, there was a statement issued on behalf of the Justice Minister later, a couple hours later, but he was never to be seen from again. He emailed some of these groups, emails purportedly from the Justice Minister, former Justice Minister, to these groups. But it seemed clear that his position was in jeopardy, and indeed he resigned as Justice Minister last night, Friday night. Probably jumped before he was pushed. Hard to tell what was going on in the background. A new minister has already been named. That is Tim Hallman. The Environment Minister is now going to be also the Justice Minister. Very capable individual, former teacher. Seems to be doing well as Environment Minister, and I think is a good replacement. It's interesting, in the provincial government, there's only one lawyer, is Becky Drouin, the Education Minister. Peculiar that she wasn't given more consideration for justice, but perhaps that's it. The irony to me in all of this is that it was these comments that got the Justice Minister in trouble, in a sense, but not the lack of action. Like, from my perspective, the complete lack of action on these key recommendations. I think probably the best recommendation from the Mass Casualty Commission was on gender-based violence, which was, let's change the way we address this. Right now, And I see this all the time. It's, you know, uh, you know, woman calls to the police, has an issue with her partner or with a boyfriend or whatever, wants him out of there, and you know, that's it. They needs a break, needs some time. Often they break up, but often they don't. But what happens is that the person gets charged and goes through the system. It's expensive for the family because he needs to get a lawyer. He's on a non-contact, so he needs to go live somewhere else, and and it just goes on and on. And so, because of all of that, the sort of the policy of taking these things, to the nth degree in the criminal justice system, many women are then reluctant to call it in because they know, all right, I'm going to have to go testify. We might be trying to work things out. He's gotten help in the meantime, gone to counseling, and things are working out. Well, now I've got to still go and testify, and it's just not the way people want to live their lives or their relationships. So the Mass Casualty Commission advised that all right, let's rethink how we deal with these things and do it in a more restorative manner. Well, from my perspective as a defense lawyer in the system, nothing like that has even started. So the irony of it all, in my view, is that the Justice Department, which doesn't seem to be taking this recommendation seriously or doing anything about it, should have been criticized for that, and yet it is these sort of offhand, ill-considered remarks of the minister that get all the comment, all the attention, and created all the problems. So, question is, what is the plan? Is there a plan? That'll be up, something for the new minister perhaps to discuss. I know Judge Zameer had asked for this. This was part of the reason for the delay in the Desmond inquiry report. Asked what the plan was from the province on domestic violence issues and approaches, because he was going to make his own recommendations, and he wanted to know, well, is the province reacting to the Mass Casualty Commission report? They weren't, or they didn't provide a response at least. So, all right. So, anyway, that's the 4th anniversary of the Portapique shootings. Not typically a big fan or a big commemorator of anniversaries. I'm not sure why we always do these things. 4 years certainly is but there's a lot of things that get commemorated every year. Overdone in my view. Okay, next story. The Zameer case out of Toronto. So this case is not going well for the prosecution at all. As Paul Palango said, the police are very heavy on this, putting pressure on the Crown, showing up at court completely inappropriately, in my opinion. Should be some leadership from the police force in Toronto, preventing these officers from stacking the courtroom and putting that kind of pressure. This guy's going to be found not guilty by the jury. We can see it coming. So the issue this week was, all right, they're getting to the point where the judge is giving instructions to the jury, and this is a very a lot of thought goes into these instructions, and the judge will provide draft instructions usually to defense and the Crown lawyers for comment and submissions, and if there's arguments to be made on these instructions, they may get made. In this case, the judge gave instructions to the jury to the effect of that the Crown theory of the case, there's really, the evidence doesn't support it. All right, the Crown is saying that the officer that was run over was standing up at the time, and Zameer should have seen him. Well, the video doesn't support that. 2 accident reconstructionists, their reports don't support that. And the judge says, well, the 3 officers that were there, along with the officer who was killed, all say that he was standing up in front of the car, was hit, and then went up on the hood of the car. There was no evidence of that. No, the dust was still on the car. There was nothing to indicate, nothing, no dents, no nothing, no markings, nothing that would indicate somebody, swept over the hood of a car. None of that stuff was present. And so the judge says to the jury, you should take this into consideration that the three people all told the same false story. And so that is probable that they colluded on that story. And that must mean something. So that's what the jury is. And then when the jury, so a lot of this will happen when the jury's not present, when there's a discussion about, all right, what are the instructions going to be? And the other thing the judge asks the lawyers on both sides in a jury trial is to present your theory of the case, because the judge will then take those theories and pass it on to the jury. And basically the judge was saying to the Crown, like, are you really, how can you persist in this theory of the case when the evidence is pointing the other direction? But the Crown did persist. So not the way they're supposed to certainly present a case. I know in Nova Scotia, following the Marshall inquiry, that was always the case. Well, you're not trying to win, you're trying to present the evidence in a fair way. In this case in Toronto, the Zameer case, it seems like the Crown is succumbing to the pressure from the police and trying to present the case the way they want it presented rather than the way it is. So the issue is a few things. One with Zameer, it's whether he knew it was a police officer. It seems obvious that he didn't. The officer was in plain clothes. The officers are saying that they went up to the window and presented their badges. There's no evidence of that. And so that would change it from a second degree to first degree murder if he knew it was a police officer. The second thing was whether it was reasonable that Zameer drove the way he did under the circumstances, and whether he had a reasonable fear of the whole situation. And again, it seems like the jury's going to find that he did. The judge is certainly pointing them in that direction. The judge is to sort of outline the law and how that works, and then the jury is supposed to be the fact finder. But you'll find in these jury instructions that there's quite a bit of guidance from the judge, and the judges will often seek to narrow what the jury fact-finding mission is going to involve. Instead of just saying, all right, you heard the evidence, off you go. The jury instructions can take several hours to go through, so it's a deep process. Anyway, we'll obviously be watching for that. The jury was sequestered, so that's the other thing. So the media is not allowed to report on what was argued in the case without the jury present until the jury is sequestered off to deliberate. Once that happens, well, then all of this is liable for or is open to be reported. And so that's where we, now that the jury was in, unlike the Saskatchewan case I mentioned before, the jury seems to be ready to take a little bit of time to go through things. Some expert reports, lots of witnesses, so I'm sure they'll want to deliberate on that for a while. All right, so that's one jury situation. Another jury situation down in the States is with the Trump trial in New York. So some extraordinary steps taken here. The names and detailed information on the 12 jurors who have been selected are to be kept confidential. There was 2 jurors dismissed, one of whom was dismissed on her own volition, her own request, when she was expressing concerns to the judge that her safety, her identity was going to be, she felt was liable to be revealed, it was at risk. And so she asked to be dismissed, and it was granted. So it's difficult to pick a jury in this case, and it went a while because, a jury of your peers, well, Donald Trump is pretty much peerless in that sense, so difficult to get. But he complained because it's a jury made up of people that live in Manhattan. Typical, it's a strongly democratic jurisdiction, and he was concerned that he wouldn't get a fair trial. Seems like the jurors have been scrutinized quite heavily. So lots of information on them, what they do, their social media postings, their profession, where they live, their hobbies. All of these things have been analyzed by the lawyers for both sides. When I first did a jury trial a couple of years into practice, this is maybe 15 years ago, we would get information on The jurors, we would get their names, where they lived, and their profession. And that's about it. And then you'd see them, try to get a sense of their age or anything else. But that was it. Try to gauge what you could by how a person was dressed or whatever. But you don't know very much. Now it's even less than that. They don't give you a list of the jurors with their, occupation, anything about them. Very difficult. I prefer to know more about the jury, and I think the Canadian system could use some, some adjustments to make that a more fair process. But hopefully, we won't get to the stage where, juror confidentiality or the identity of the jury needs to be kept secret and all those kinds of things that's happening in the States. So that trial is going to start Monday. The judge is trying to keep doing everything he can to keep it on track. Anyway, the trial itself, it's the Stormy Daniels thing and, business records and all that kind of stuff. Seems like a way to get through the back door, which you couldn't get through the front door. Not the strongest case against Trump. I'll be curious to watch it unfold. All right, so moving from those jury cases back up north of the border, we had the budget this week. Just looking through some of the justice issues that were in the budget. There was some money dedicated to gun. So when you look at a budget is much of a communications document as it is a financial document. And so in the justice world, this is what the government has identified as its priorities. Gun and gang violence, gender-based violence. There's a national program for body-worn cameras for RCMP officers, frontline RCMP officers. Supporting youth in the justice system. Rehabilitation programs, hopefully. Wasn't clear from the document. Security infrastructure for hate-targeted communities. All right, so if you're a hate-targeted community, you need some, surveillance cameras, other security infrastructure. There's money for that. Anti-car theft money, including significant budgetary influx for the Canadian Border Services Agency. That's certainly a good thing. There's a buyback program announced for assault-style weapons. Not so sure about that program. Certainly the guns rights and hunter groups, people would certainly agree that this government is taking strong action or taking too much action on the gun side. Not the kind of action that would have been that's been recommended by either the Desmond Inquiry report or the Mass Casualty Commission report. So it's not fact-based evidence; it's fear-based policy. All right. So money for Online Harms Act that's imminently going to be passed. Certainly the child protection and non-consensual sharing of images side of it, and then money for a review of the Canadian sport, the Future of Canadian Sport Commission, dealing with sexual assault cases in Canadian sports and trying to address that. Notable was, so there was a section on judges and noted that, this is the shot at Alberta, noted that Alberta has 17 allocated judicial spots. Across the country, access to justice is a big issue. The federal government was criticized a few times in the past year for not naming judges. It's gone to court to ensure that the federal government names a sufficient number of judges to handle the caseload. Well, they've come out in this budget saying that Alberta has 17 allocated spots unused in the unified courts, which is basically the family court moved up to a Supreme Court level. So those 17 allocated spots are going to go elsewhere. Other provinces who have requested more judges will get some of those 17 spots. So be interested to see where those go. Suspect, of course, Ontario is going to get many of them, but could use a few here in Nova Scotia as well. All right, speaking of Nova Scotia, I want to cover a couple of cases. One involves Jeremy MacKenzie, who rose to some fame or infamous through his pandemic activities across the country. So he's charged along with Morgan Guptill, name I'm not really familiar with that name, and he's charged in Nova Scotia with mischief, with criminal harassment, with harassment through telecommunications, and with intimidation and impeding health services. So he's an anti-vaxxer, so we can kind of guess what that's about, but we don't have the details of the charge as much in this decision. This is Judge Jill Hartland, a fairly new judge, named last year, but highly capable, and a good decision here. MacKenzie is represented by two Toronto lawyers, Sheriff Foda and Rick Frank. So that's interesting. Charged out of Dartmouth. And when he was charged, he was arrested and asked, he says, to speak to Stan McDonald, top 5, top 3, maybe top 1 criminal lawyer in Nova Scotia. And Jeremy MacKenzie wanted the officers to place a call to Stan McDonald. They didn't do so. And so that was one part of the factual scenario. So MacKenzie was alleging that his right to counsel was violated, and thus the charges should be dismissed, or at least that any evidence gathered after that should be excluded from consideration. I'm sure he wants the charges dismissed. That is one potential remedy for a charter breach of this nature. Okay. But the police had a note from a Constable Adam Power that said that he was the sort of officer like in charge of the booking that night, made a note that MacKenzie had called a lawyer. Didn't name the lawyer, didn't say where. But presumably a very good chance that is legal aid duty counsel, who happened to be a guy named Damien Penny that night. So the Crown wants to call Damien Penny and the head of legal aid in Halifax, Barry Wynot, to testify that, all right, there was a phone call made and duty counsel answered and gave Jeremy MacKenzie some advice. Well, both sides, not both sides exactly, but legal aid is saying that that kind of evidence would violate solicitor-client privilege, MacKenzie's solicitor-client privilege, and they want him to sign a waiver before they will agree to have Barry Wynot testify. Or, while Damien Penny is not legal aid, so he can decide himself, but this is legal aid's position, is that they want Jeremy MacKenzie to sign a waiver. MacKenzie refuses to do so. Crown says you can't assert privilege over a call that you say doesn't exist. But MacKenzie says, well, that's kind of beside the point. He said, well, it was the call, he wanted the call to Stan McDonald, and whether it was legal aid or whoever, that wasn't what he wanted, and so it doesn't matter who else got the call. So the disappointing part is we don't actually the judge doesn't get into the substance of that question, because the application was to quash the subpoena of Barry Wynot and Damien Penny, the two lawyers. And the judge says, well, if you want to quash the subpoena, the only way to do that is not in provincial court where we are. You have to take that to Supreme Court. And so it was a simple jurisdictional question. She said, we don't have the jurisdiction to answer this question, so I'm not going to. So there you go. It must go to Supreme Court. But it would be very interesting to hear this argument when it does come along, because you are entitled to the lawyer of your choice, and the police, all right, so the police are supposed to at least try to reach that lawyer. And often people say, give me Joel Pink, give me Stan McDonald, give me somebody that just the only name they can think of. And you got to try. So if you can't reach him and there's no answer, or he doesn't want to talk to them, well, then you call duty counsel or call somebody else. So there'll be an application forthcoming, no doubt. Last thing, just to mention very quickly, is a decision from Judge Duffy it's a domestic violence case with a single complainant who was then moved immediately thereafter to Ontario. Crown says it would cost about almost $2,000 for the person to travel down, fly down, and all that stuff. They'll have to miss work, all these things. Let them testify by video. Now, there is case law in Nova Scotia that says, well, if it's just some expert evidence on, a blood sample or something, and credibility is not a question, you just need to get the evidence in, go ahead and do it by video. But if credibility is in question, then it has to be in person. Well, this changes that, because what the judge says is this: well, it's a relatively low-level offense. There was no injuries alleged or anything like that. No, so it's a fairly low-level assault allegation. And so if in those circumstances there's some flexibility, and by the way, technology's gotten much better even over the last few years since that other decision was made. And so even if credibility is an issue, as long as it's a low-level thing, and the judge kind of reserves the right to listen, or if we get into it and the technology is not working well, then we can call it off. But she did grant the application, so it's going to change the way things are working. It'll make things a lot more efficient, but it is different to have somebody there in person sometimes than by video. So we'll see how that develops, but it's certainly opening a crack in the door to allowing many more appearances by video with this new decision. So, all right, so that's what I wanted to cover for this week, and thank you everybody for joining in on that. Well, like I said, we'll be back tomorrow night with the Sunday night show at 9:15 on the Nighttime Podcast Network. Jordan did a nice thing last night. He did a walkthrough in the new park in near Portapique with Darcy Dobson. Worth checking out if you're looking for something else to watch in the meantime on YouTube. Just go to the Nighttime Podcast and you'll see that. And otherwise, we'll see you tomorrow night. So thank you everybody for watching. Thank you for listening, and we'll see you next time.